Hello, everyone, and welcome to this Federalist Society virtual event. I'm Caroline Bryant, and I'm the Associate Director of Practice Groups with the Federalist Society. Today, we're excited to host this webinar on the Disinformation in Broadcasting and the Public Interest Standard. Our moderator today is Patricia Paoletta. Patricia is a partner with the law firm HWG LLP, where she specializes in telecommunications, trade, and technology policy. Prior to joining HWG, she was Senior Advisor to the International Bureau Chief and Office Director at the FCC. She also served as Director of Telecommunications Trade Policy in the Office of the U.S. Trade Representative, Executive Office of the President. She's also served as Majority Counsel to the House Energy and Commerce Committee. If you'd like to learn more about today's speakers and moderator, their full bios can be viewed on our website, fedsoc.org. After our speakers give their presentations, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A function at the bottom of your Zoom window, and we'll do our best to answer as many as we can. Finally, I'll note that, as always, all expressions of opinion today are those of our guest speakers, not the Federalist Society. With that, Tricia, thank you so much for joining us, and the floor is yours.
Well, thanks, Carolyn. And I'm very excited to be here to moderate this very timely and hopefully exciting panel on what exactly the FCC can do under its statutory obligations to regulate spectrum licenses consistent with the public interest, convenience, and necessity. This was a bit of an education for me too, because I'm not a media lawyer, so I'm going to indulge folks on I think most people, of course, hopefully in America know the very first amendment to our Constitution was to ensure that, or to state that Congress shall make no law abridging the freedom of speech or of the press. But 90 years ago, when Congress created the Federal Communications Commission, it actually required, again, to require the FCC to issue licenses for the use of spectrum, including broadcasting, so long as those licenses were consistent with the public interest, convenience, and necessity. So already you have a little bit of a condition, right? After World War II, Congress added to the Communications Act that the FCC had no rights to censorship. Presumably, the threat from adverse allies around the world was passed, and it stated very clearly that the FCC could not interfere with the freedom of speech, by the press. So you have these two sets of legal parameters that guide the FCC. And so it would be a very interesting time to talk to this panel. Back in the 60s, to make things even more complicated, the FCC did develop the news distortion policy, which is now incorporated into some of the conditions of broadcast licensees. And it basically prevents or maintains as a condition of license that broadcast licensees do not intentionally distort the news. So we're going to explore these various issues. Carolyn gave a probably overlong bio for me, introducing me. I'm going to be very quick because these guys are going to be way more interesting than my rattling off their bios. And of course, it's all on the website. But we'll start alphabetically with Bob Corn-Revere, who is Chief Counsel to arguably the think tank with the coolest acronym, FIRE. And that, of course, is the Foundation for Individual Rights and Expression, perhaps, but he'll explain if I get that wrong. He has been listed as, a best lawyer in First Amendment litigation. He's in the Washingtonian Hall of Fame for top lawyers. That's pretty impressive. He's written some very interesting books. Short title, The Censor's Dilemma. Thought that was pretty cool. He's written a treatise on modern communication law that might be a little less interesting, maybe something to turn to when you're up in the middle of the night, but for you budding communication lawyers, probably a good thing. But the coolest thing that I've seen in any bio and any panel I've ever done, he was the first lawyer to get posthumously a pardon from the governor of New York for Lenny Bruce, who had been convicted of indecency, right? Oh, no, obscenity.
Obscenity.
So that's pretty impressive. Now our other panelists, they're much younger than Bob and me, so they got time to embellish their bios. We have David Gibber, who's the Executive Vice President at Sinclair Broadcast Group, in which capacity he serves as the Chief Legal Officer. He's been there for almost 15 years. So he's had the broadcast licensee experience of seeing how the FCC manages kind of this narrow window where they can regulate but not infringe on First Amendment rights across multiple administrations, with FCC chairs who have been appointed by Republican presidents and Democrat presidents and back again. So his perspective as a broadcast licensee will be very interesting. And then last but not least, we have Daniel Suhr, who has the second best acronym for a think tank, maybe the best in the current CAR FCC. His think tank, CAR, but with one R, is the Center for American Rights. And in that, he promotes free expression, freedom of parents to be involved in education, a range of issues. Maybe he and Bob are coming down in a different space on what the right balance is. So we're going to get into that. Daniel has served governors. He's served lieutenant governors, judges as a clerk for the Seventh Circuit. He, like me, is a Hoya graduate. So, I'm sure he's an excellent lawyer. Without further ado, we'll turn to Daniel first to explain what recently has CAR filed on news distortion and other First Amendment issues at the FCC and exactly why. So over to you, Daniel.
Yeah, thanks so much, Tricia, and good morning, everybody. It's a pleasure to be with you. So our fundamental belief at the Center for American Rights is that we need a renewal and reform, really, in our media landscape. And it starts with this fundamental insight. According to Gallup polling, only 31% of Americans trust the mainstream media. That means that 2/3 of Americans, 69% of Americans, don't trust our major media institutions. When we look at the FCC, the charge that it gives to licensees is that they are to be public trustees of the public's airwaves. But what do we do when the public doesn't trust the trustees that are supposed to be the stewards of the public's airwaves? I think really that's the question that we're confronting in this panel, and the question that's brought forward in the complaint that my firm has filed with the FCC. So this really started this conversation based on a complaint that we filed in October of last year. You may remember 60 Minutes ran two different versions of the same answer that Vice President Kamala Harris at the time gave in her one big first initial sit-down interview with the media. If you watched Face the Nation, you saw Bill Whitaker ask her a question, and she gave one answer, and yet the very next night, if you watched her in the exact same interview with Bill Whitaker, Bill asked the same question, she gave a completely different answer. And so in our view, that is manipulating the news. That is a form of what we call slice and dice journalism, where it is not real journalism. It's the journalists distorting the news. Other ways the FCC has talked about it is slanting the news or rigging the news. And look, I realize that journalists do this every day. I talk to journalists on the phone all the time. Print journalists decide what quotes to run and what quotes to leave out. That's part of the journalistic business. I get it. But there's a certain point at which that crosses a line that the FCC has drawn historically. And it's also important to remember that I think the standards are frankly higher for broadcast licensees. The Supreme Court has always recognized that the First Amendment operates differently in the broadcast context, and that the public interest standard incorporated in the Communications Act allows for some accountability on the part of the Commission when broadcasters fall short of their public interest obligations. So our belief is that that's what CBS did here. There's a public comment period that just closed last week with replies coming up. It's file 25-73 for any of you who really want to dig in. There's a similar proceeding with CBS right now regarding the Paramount Global purchase by Skydance, where Chairman Carr has also said a lot of these concerns about news distortion and news slanting are going to come up. So my expectation is this is going to be a continuing area of development and interest for everybody in the telecom bar. But really, from our perspective, the goal is pretty simple. It's to ask that question, how do we restore public trust in the media that uses public airwaves? And our belief is that accountability when there is news manipulation and transparency, which is what we got when Chairman Carr ordered finally the disclosure of the transcript from the 60 Minutes interview, are important steps to restoring that public trust. Thanks,
Yeah,
Tricia.
thank you, Daniel. Did one of you say something? Was that Bob? Oh,
I've got lots to say.
Bob, I'd love to hear your response. I know you also filed in this proceeding. So what does Fire have to say about, particularly about the CBS complaint?
How long do we have?
I'll give
No,
you
when
10 minutes. That's it.
when I hear discussions like this, I have to wonder whether or not the ghost of Richard Nixon is somewhere wandering around the White House grounds, muttering to himself, "How do you like me now?" I think we filed a 30-page set of comments in this proceeding on the 60 Minutes news distortion complaint, basically describing it as a political stunt. And I think it's based on a fundamental misunderstanding of either communications law as has existed since 1934, and even before that, really. And it also is based on a fundamental misunderstanding of the news distortion complaint. I think Daniel makes a couple of errors in how he approaches this. First is in assuming that the public interest standard for licensing broadcasting gives the government a fundamentally greater and different role in regulating what can be on newscasts. Tricia, as you pointed out at the beginning, the Communications Act even limits the FCC's ability. It prohibits it from engaging in censorship. And that's existed in the law even before World War II. It's existed from the beginning of the 1934 Communications Act. It existed even before that in the 1927 Radio Act. And so the FCC has historically interpreted its ability to regulate programming and particularly specific newscasts under that public interest mandate. And it probably was at its peak in 1969 when the Supreme Court decided the Red Lion case, which upheld the FCC's constitutional ability to impose, at the time, what was called the Fairness Doctrine. Even then, the Commission was not given a long leash in how much it could regulate content. And that leash has shortened over time. In the mid-1980s, the FCC looked at the Fairness Doctrine itself and said that this was giving the government way too much power to regulate news, and it ultimately eliminated the Fairness Doctrine. The news distortion policy under which this 60 Minutes complaint was filed has always been limited, and with the understanding that there are both limits in the Communications Act and in the First Amendment for how far the FCC can go. But the important point is that the FCC never believed this news distortion policy would give it the ability to regulate individual broadcasts and to tell newscasters how they should edit their programs. It was adopted originally, or at least articulated. It's never been adopted as a formal rule, but it was announced in 1969 at the height of the FCC's authority to regulate content at all. And even at that time, the FCC said it was not going to get into these individual editing decisions, that would be a quagmire. It was really notable that 2 years after it was announced, it was dealing with a program called The Selling of the Pentagon, where news distortion complaints had been brought to the FCC about a CBS documentary. And one thing that you had with a unanimous commission, and at the time it had 7 commissioners, not 5, you had a unanimous commission saying that we're not going to look at these individual editing decisions about whether or not one answer was placed before one other. As long as the broadcaster was making its own editorial judgment, that was fine. And if you remember those times, it was probably as polarized a time in American politics as we've ever seen up until the present time. At the time, the chairman of the FCC was Dean Birch. He'd been a former chairman of the Republican National Committee. And we probably had the most left-leaning and most liberal commissioner at the time, Nicholas Johnson. Those two men couldn't agree on anything. As a matter of fact, they really hated each other. But one point on which they agreed is that it would be improper for the FCC to look into news judgment in this way. They described it as a quagmire that they're not going to get into. Daniel says that only 31% of the public trusts mainstream media. To me, that seems to be the answer to his problem. It's not a question for government oversight, for the government to make sure that broadcasters or newsmen of any kind behave. The question is, how far do you want government to go in being able to dictate how programs should be edited? And so this current complaint at the FCC really is an exercise in really government run amok in terms of how far you can look at editorial decision making. And frankly, I think the FCC is embarrassing itself, and it should dismiss this immediately. I should add one other point about this, and that is a week before the inauguration for the second term of Donald Trump, the FCC had dismissed this complaint along with three others involving both an ABC complaint for news distortion, an NBC complaint for equal opportunities, this complaint, and one against the license renewal of the Fox affiliate in Philadelphia. And one of the first things that Brendan Carr did upon assuming the chairmanship was to reinstate the complaints against ABC, CBS, and NBC, but not against Fox. Now, all four of those proceedings should have stayed where they were and had those complaints and the challenge to the license ended. But the FCC, unfortunately, has resumed consideration of the 60 Minutes complaint, and I think that is really an exercise in unconstitutional jawboning.
Well, thank you, Bob. But let me ask you, though, because the news distortion policy does remain on the books. Let me ask you briefly, and then Daniel, and then we will turn to David.
Sure.
Yeah, how does FIRE define the news distortion policy?
Well, the news distortion policy, and this was explained in the early decisions from 1969 when it was first articulated, and probably the best example of that when they were at the Democratic National Convention, some allegations were made that newsmen were prompting demonstrators to, like, handing them a brick saying, throw this through a window, or here are signs you can now demonstrate. It's essentially staging the news. And it drew a strict line in that decision for the 68 Democratic National Convention, in the Hunger in America complaint in a documentary in 1969, and then later in the Selling of the Pentagon complaint in 1971. In all of those, it said that news distortion includes this kind of making things up, but does not include these kinds of editorial decisions about how much of a quote to use or where to place the emphasis in a quote or things like that. It simply was not what news distortion was. And so renewing this complaint at this time is not even consistent with the news distortion complaint when it was first conceived, when the FCC was at the height of its power. Now, in the years since, with the FCC's ability to regulate content diminished greatly due to subsequent court decisions, to keep faith with that original notion of news distortion, you would have to dismiss this complaint.
So Daniel, back to you then. How does Carr define the new, and Carr with one R, define the news distortion policy?
Yeah, I look to a more recent decision, and that's the DC Circuit's decision in Serafin versus FCC. It was written by Doug Ginsburg, who I assume Bob otherwise respects as a fellow libertarian. But in that case, the FCC looked at actually another 60 Minutes complaint and acted much as Bob suggests, had dismissed it, and the complainants appealed to the DC Circuit. And the DC Circuit reversed and sent it back to the commission. And I think in that case, laid out frankly, a higher standard than the one that Bob is suggesting. That case involved a 60 Minutes interview that was, again, an example of this kind of slice and dice journalism. There was a cardinal of the Roman Catholic Church. There was the chief rabbi of Ukraine who said that their comments had been wildly distorted and taken out of context. And the DC Circuit said that there was enough there that the FCC should take it seriously and investigate those decisions. So I think that's both a more recent decision, and I think it's very on point to this conversation to look at Seraphin.
Well,
Thank you,
except
Daniel.
if I could just respond to that briefly.
In 10 seconds, because poor David.
I can do it. I can do it in 10 seconds.
I'm enjoying this. Go ahead.
The FCC said nothing about First Amendment issues in the I'm sorry, the DC Circuit said nothing about First Amendment questions in the Seraphin decision and sent it back to the commission only because the commission failed to explain why it was dismissing the complaint. It didn't deal with any of the issues that are in question here, or the ones that were originally when the FCC defined the news distortion policy.
Thank you. All right, David, you're the broadcast licensee. How have you been managing these years, walking through that sticky wicket of the news distortion policy out there? And of course, you've had some challenges to renewal of Sinclair's licenses over the years. Maybe you can share some of that experience.
Sure. And thank you for having me. And good morning, good afternoon, everyone. It's definitely interesting listening to Daniel and Bob. And I think from a broadcaster's perspective, we welcome the conversation. I think for too long, we've had public interest groups on either side parachute in to discussions like this. And what's left after the fact is broadcasters either unsure of what their obligations are or left to deal with FCC's decisions and either published or unpublished, in which we ultimately have to pay the price. I think it's a worthy conversation to have, and I actually credit Carr for willing to have this conversation. The fact that the previous administration, the FCC administration, dismissed it means nothing to most broadcasters, given the treatment that most broadcasters, how we were treated by the last administration. And to say that it was just dismissed, and okay, what wasn't dismissed were other complaints. We have a complaint against us in Baltimore that has nothing to do with reality. That wasn't dismissed. So how come that administration decided to dismiss ones that were maybe in the news and had certain last names, but ours wasn't dismissed? So I think what broadcasters are kind of tired of, and what the challenges that we find, is that as administrations change, as public interest groups change their view on things, rules change. And we are very happy that Carr has decided to frankly just open the conversation. He hasn't said which way he will rule. And if you look at the complaint that was filed, what was the complaint? The complaint that Daniel filed was simply release the transcript. He actually says in his complaint, and I haven't heard anybody bring this up, he didn't say censor anybody. Here we're talking about censoring. Bob's talking about censoring people. It actually says don't censor. It says release the transcript, right? That's all that's happening. Now, do I think what's right or wrong to release the transcript or not? If that is a proper demand of the FCC, I think the chairman is trying to, he's inviting comment about that, and he's inviting the conversation about it. And how he rules and how he comes out in that way, I think will be instructive for us going forward and allow us to rely on that precedent. And I think it's hard for us broadcasters to hear people talk about the First Amendment and weaponizing the First Amendment in ways in which a public interest group will find to their favor. I'm sitting here in front of me. I have a letter from, on top it says United States Senate. And on it says, the weaponization of the FCC is unacceptable. It says, without any evidence of wrongdoing, these statements actually are nothing, right? You can't rely on the distortion. Don't look at the distortion policy, right? And this is sent recently to Brendan Carr and Nathan Symington, and this is signed by a couple of senators, right? Claiming that, it says the never used news distortion policy, right? That's what they say in there. But yet, here I have another letter signed by some of the same senators. This is April 11th, 2018, arguing that a certain entity should be investigated for the same thing that they're arguing in 2025 that they shouldn't be used. So what you see and what the broadcasters, and by the way, April 11, 2018, 12 senators signed this. And essentially they said this entity is engaged in a systematic news distortion operation. Well, the same senators signed something that said, well, it's unacceptable. So it's very hard for us as broadcasters to listen to the argument about what free speech is and what free speech isn't, depends on how the wind is blowing. And I know Bob and I think Bob and Daniel actually agree in many ways more than they disagree in how important the free speech.
Don't be so sure.
Right. I said I understand how I believe we all sitting here understand the importance of the First Amendment. But I think what broadcasters, as a broadcaster's perspective, is we've seen the weaponization of it time and time again. And I think we welcome the conversation by Chairman Carr to understand what our obligations are and are not. And I'll just end with, before we open up, I think we open up the question as well, which is, I think there's a fundamental disagreement that's happening between Daniel and Bob as well, which is, if you look at Bob's 30-page response, which is about the scarcity and whether the FCC really has an obligation or the right at all at this point to regulate certain aspects of broadcast. But that scarcity argument has been used to regulate both ownership, regulate other parts of broadcasting. And if Bob is correct, then I think the FCC you can't pick and choose. The FCC can't make the argument that, oh, you know what? It's scarcity doesn't exist anymore and make that argument, but then we want to layer on other regulations on it. So I think what we've seen as broadcasters, unfortunately, is what many have seen with the government, and it's been the weaponization of regulations, weaponization of certain aspects of the First Amendment. And as depends how the wind blows, it depends which way it's used. And sometimes you look at this and I don't know how the commission's going to come out in this way. I'm hoping it comes out in a way that the broadcasters can have certainty and can base our operations on it. And in addition to that, we talk about mainstream media, that there's a low level trust in mainstream media. There's still a high level trust in local media. And I think this chairman has welcomed and championed the fact that we have to figure out how to empower local media. So again, like I said, I'm excited to see how this FCC interacts with local media, interacts with local broadcasters. I think the chairman has said that he's not going to judge people based on their last names. I think that hasn't been true previously. And again, like I said, I don't think he has prejudged this based on what I've seen. And I think he's just opening a conversation.
Thank you, David. I'm certainly agree. I'm sympathetic to your point that we should have that conversation. What is the public interest standard relative to broadcast? Because despite the brilliance of my my panelists from the think tank world, I didn't hear a clear definition of what the news distortion policy permits or doesn't permit. And again, I know it's not used often, but so it would probably be good to have some transparency on that and have the public more engaged in that discussion. Reactions, we'll start with Daniel hasn't spoken as much. We'll start with you, Daniel. So.
Yeah, thanks. I think maybe just two thoughts. One, obviously sympathetic to the situation Sinclair has been in. I think part of this is a little bit of conversation about what kind of conservative you are. So I really appreciated the comment that Chairman Carr made the other day in a news interview. Fair is fair. That when we had the previous administration, Sinclair was targeted with these news distortion complaints. The commission did not initially dismiss them. They held a public comment period on those complaints. And Chairman Carr was critical at the time of the decision to hold those comments and hold those files open. We come into this new administration, and I think the theme that I'm hearing from the chairman right now is fair is fair. And that's, I think, the attitude we're taking at the Center for American Rights, is to say, if this policy is on the books, and if it's going to be applied to Fox and Sinclair, then it is equally fair that when CBS or ABC engage in transgressions, that they should equally be brought in front of the commission on those violations. So for me, it really comes down to, I think, that second insight, which I appreciate from David. The other thing I think that David helped clarify that I would also respond back to with Bob is that important difference in censorship between prior restraint and after the fact accountability. The line around prior restraint is a line that the Supreme Court has always drawn to say that the heart of the First Amendment, especially in the press context, is that we can't have prior government clearance of the news or reporting or the press. Totally understand, get it, agree with it. The Commission, however, has also always said that as part of its public interest obligations, it can review the actions of its licensees. I think, again, one way to phrase the question we're posing is, what do you do when the public doesn't, as a regulator, what do you do when the public does not trust your licensees? If 2/3 of the American people didn't trust the airlines, I think the Department of Transportation would say, gee, that is a problem for us as the licensor of airlines, that 2/3 of the American people don't trust the people we license. And so I think that David's right in bringing that up. I think he's right in focusing on local news. One of the things that we've actually called for in our Paramount filings, use more content from local stations. Move in national broadcasts, move editorial functions for national networks out of Hollywood and New York, move them to a place like Dallas, move editorial functions to other parts of the country, bring in more local journalists on national broadcasts in order to serve the public interest through the diversity component of the public interest standard, the viewpoint diversity component of the public interest standard.
Thank you, Daniel. Okay, Bob, your response.
Well, it's hard to know where to begin because Daniel has laid out a really ambitious role for how far government can intrude in how media should operate. Frankly, it's not the government's job to make our media trustworthy. That was the attempt made for years under what was called the Fairness Doctrine. And finally, under a Republican administration, the Fairness Doctrine was eliminated as being too intrusive into broadcasters' editorial prerogatives. The idea that we're talking about prior restraint is really not the point. It was made clear by the Supreme Court as far back as 1931 that the First Amendment protects against more than just prior restraint, and that it protects broadcasters in their editorial judgment. One of the great things about being at FIRE, well, two great things about being at FIRE is, one, we don't engage in whataboutism. We don't say, well, what about that other administration or that administration? Regardless of who it is, if they're violating the First Amendment, we're going to call them out on it. And the other thing that's great about being here is that I don't have to care what Brendan Carr thinks. And frankly, I don't, because given his prior statements about how government shouldn't be involved in newsroom judgments and his current actions in actively engaging in looking at newsroom actions, then I think we need to come up with a stronger word than hypocrite. If you're judged by your actions, then these are completely inconsistent with his prior statements. And I would take issue with the idea that all that Brendan Carr has done is ask for CBS to release the transcript. They did that. Instead, he opened a notice and comment rulemaking proceeding in an adjudication about whether or not a rule has been violated or a policy has been violated. There was reference to the notice and comment period open for Sinclair. That was in the context of a license renewal proceeding where public comment is traditionally permitted. But here, we're asking a poll of the American public whether or not they think CBS violated a rule. It's simply absurd. And I would invite you to take a look at the comments that are filed. Many of them are simply form comments. Others are simply trolling the commission. And then there are a few substantive comments like the ones that we filed in there as well. But I don't think the FCC is going to gain any insights about whether or not CBS has violated any rule by looking at those comments. It really is instead just a proceeding designed to impose pressure on the network to make editorial judgments that is more consistent with what I think the chairman would like to see. And I would echo the point that David made, saying that You don't get to pick and choose when you're going to enforce these rules or not. I agree completely. These decisions should be consistent across administrations, and the government shouldn't be involved in these editorial judgments. And if previous administrations lean too heavily on some broadcasters, that should be a cautionary tale for why the government should back off and not be involved.
So can I just?
Yes, please, David.
So it's interesting, Bob, that you say that, it's typical that during transactions, we open it up for comment. But the question is, why? I mean, if somebody is offended by the fact that he's opening up this to comment, why are you not offended by the fact that we open up, and frankly, often what we have is public interest groups that are funded, whether you call them AstroTurf groups or whatever you want to call them, are funded by people who really have a vested interest in this. They come undisclosed. They come in, they don't disclose where their funding is from, and they wreak havoc on the FCC process, right? So if we're going to have a conversation about comment periods at the FCC, obviously we welcome that. But again, it just seems, and I'm not picking on you, Bob, in terms of this approach, but I will tell you, on April 11th of 2018, the ACLU did not come out and say, we think this is a bad idea. FIRE did not come out. I know maybe you were still in the education business at the time, but in 2018, free press, and First Amendment groups did not come out and say, oh, these 12 senators are out of control. That's not what happened. So again, you're right that people are picking and choosing, but I think the FCC, the fact that they're working within the system that they have, and the fact that they said we're opening a comment period, that itself doesn't strike me as odd. It doesn't strike me as different. If the FCC takes this opportunity to say, you know what, we don't need any comments from the public when we review transactions. We don't need, Dish's, AstroTurf groups to come in and say that this transaction or that transaction is not good because it hurts some make-believe issue on that. But I mean, that's the problem that we see at the FCC. It has been weaponized over and over for special interests. And it's not just the FCC, frankly. These are senators. These are senators that are writing letters. You want to talk about hypocrites? I don't hear FIRE saying, why are you such a hypocrite? Because you know what, in April 12th of 2025, they're taking your position, but in April 11, 2018, they're not taking your position. So again, I'm not calling out you particular on FIRE. What problem is what we see both at the FCC, we've seen it at DOJ, we've seen it at FTC, but as an entity as a business, the government and the FCC should try and figure this out. Because again, if you're going to say, well, we are the public interest groups and we're representing the public interest, again, for us who have been through this process many times, we look at that with a very wary eye, because we have seen public interest groups that aren't public interest groups. And I don't know who funds FIRE. I don't know who funds CAR. I don't know who funds any of this. But I will tell you, but historically, right, the public interest groups have not been on the side of public interest.
Well, if I could just respond on behalf of FIRE, because David, as you pointed out, FIRE had been focused specifically on free speech in higher education up until 2 years ago. And since that time, and I came in-house at FIRE shortly thereafter, and since that time, we have focused on broader issues, free speech in society at large, and at the FCC. And so we have begun to file comments in proceedings like the proceeding last fall on regulating AI and requiring announcements, or proposing to require announcements of use of AI in political advertising, or now in the CBS proceeding. I agree with you that the commission and certain people on the Hill have been too active in trying to regulate what licensees do across the political spectrum. And that's one of the reasons why we're getting involved. And we shouldn't allow the ability of the FCC in the past to regulate to be brought into the current conversation and weaponized and to be used against only certain broadcasters. I agree with you that it shouldn't be a situation where you pick and choose. which is precisely why we're in this situation now, because complaints were dismissed against 4 networks at the end of or the middle of January, but then restored as to only 3. And that kind of selectivity is a problem.
Right.
And
And
I think
we
the fourth
just,
one was
we had a
dismissed.
complaint that wasn't even dismissed by the Rosenberg administration.
all right, and Daniel, and I'm gonna start getting into some of the audience's comments and questions. Go ahead, Daniel. You had
Well, just in fairness, there was an additional reason the Fox complaint was treated differently, and that's because they tried to take something that happened on cable
That's
and
right.
smuggle it through to broadcast, which I think is a legitimate distinction. We don't go after MSNBC, even though it's owned by the same people as NBC, and therefore we could go after NBC license. Like, I think that's a legitimate line to draw.
It's a great segue, Daniel, because, and as some of our audience has kind of raised, there is this odd, different standard, and of course you mentioned it, Bob, that, and then the chairman has mentioned this, right? Well, for better or for worse, the statute gives us the right to impose these obligations on broadcasters because they're using the public airwaves. They're using a scarce resource, and people can, oh, but spectrum's not scarce anymore. Well, if you're a broadcaster and the mobile industry is licking its lips to get at your spectrum, maybe it's still kind of scarce, right? So there isn't that much more spectrum, and broadcasters can't broadcast in every tittle and hertz of the hertz out there, right? So it is arguably still scarce from some policy perspective, but the First Amendment is absolute, or it should be absolute, perhaps. So it does seem to be a disconnect as to why, the FCC can regulate one set of speakers, the broadcasters with particular obligations, but all the other platforms out there, which arguably have a more secure revenue stream, and I'm talking about, the virtual MVPDs like YouTube or the telco TVs like Fios cable, the cable operators, platforms generally, they're not subject to this. So how do you address that? Well, shouldn't the First Amendment protect all equally? How can we justify a tougher standard for broadcasters, even though, yes, they are using something that's important and doesn't grow on trees despite all the innovation in the industry? I'll start with you first, Daniel, then maybe we can hear David on that.
Yeah, absolutely. So I think 2 things. Number one, we should do a little bit, this is a Federalist Society podcast, we should do a little bit of originalism around, what the press concept means. I think Justice Thomas's opinion in McIntyre versus Ohio Election Commission is really good on reminding us that the press, as the founders talked about it, was the small printer who was printing things at his home, and it was basically meant to be a complement to speech, right? You could say something in speech or you could say something in print, and that was what was encapsulated in the press. And Justice Thomas explains, and we've seen a lot of law review scholarship expounding on this point, that our modern conception of the press as this family of large corporate media organizations is not really the same as the founders. It's not to say that those entities don't enjoy the freedom of the press. Obviously they do, but it's rather to say that these kind of special, large national or even local media organizations don't have some sort of special constitutional status different from a blogger or somebody on Twitter who might be a modern day Substack journalist, right? So one, like they're not special. They're not different as speakers in that regard. But then look, we can agree or disagree about spectrum transparency as policy. We can talk about auctioning spectrum as an alternative. From my perspective, the Supreme Court has answered these questions. I think from the Commission's perspective, the Supreme Court has answered these questions. And whether it's in Red Lion or Pacifica or other cases, the court has constantly said that broadcasters, in choosing to apply for a license and asking to use the public's airwaves, take on certain public interest obligations. And as long as that's where the constitutional law is at from the Supreme Court, if this gives us an opportunity to advance good things and restore public trust in media, we're going to use it.
David, as the broadcaster subject regulated, what's your view on the different platforms? And
it is very hard for us to look at the environment now and the ecosystem now, and you can go online and I think there's a guy named Evan Shapiro. He has a map of the media ecosystem, And, there's big planets like Apple, and there's a little bit smaller planets like Facebook, and there's Meta, and then the little star are the broadcasters, right? To say that we have something, that needs to be overregulated compared to them is very hard for us to understand. And like I said, I think our view is this administration is willing to take a look into that. Regardless of what's going to happen in this particular proceeding, I think Bob, like I said, he argues for this as well, that scarcity hasn't really existed in really related to broadcast in a long time. Now there's rules on the book, and we have to deal with the rules on the book, and we can hope, like as Daniel said, the Supreme Court has spoken. But I do think the FCC has certain leeway and how they administer certain rules and how they oversee certain rules. So yeah, we are hoping, and we believe that this administration is more open to those conversations. And I do believe that this is part of this proceeding right now is part of the conversation. And how do you deal with a company that is a broadcaster that frankly is a partner of ours? Like CBS is a partner of ours. We affiliate with CBS in a lot of markets. How do you deal with an entity like that has a lot of other interests as well? I think that's something that the FCC and the Commission is a worthy endeavor to understand and to give people certainty. I mean, frankly, the previous administration, and Bob, this is, again, I know you don't want to talk about the previous administration, but the rules on the book in which I think certain broadcasters are suing are that actually the FCC said, we used to be able to have whatever we wanted on one. We had one stick, one license, and we can have something on our D1 or D2, D3, D4. And now last administration added regulation on top of us and said, well, you can't have an ABC and an NBC on D1, D2. Was there an uproar from the free speech people, from the free speech public interest? I didn't hear it, right? And I don't think the broadcasters heard it either. So I think there's a lot of questions that need to be asked, including the question that I think Carr is asking, that Chairman Carr is asking. And I think we're open to the conversation. And I think we believe that we have somebody currently in this FCC, this administration, both Carr and both Symington and hopefully as well, people are open to having the conversation and to see and to give us certainty how we can act and how we can go forward. Not every rule is going to come off the books. And I think Bob actually's perspective, and if you read Bob's view would be that every rule would come off the book. And and that might not be a bad thing either for us. I mean, because if you get rid of scarcity argument, all of them sort of fall away. And I'm not arguing with that as well. But I think the value that we're seeing in this administration is a willingness to have the conversation, the willingness to have Bob put in a comment, the willingness to listen to what Daniel has to say. And I think there are the shifting of the media landscape, and both perspectives, both Daniel and Bob have a perspective, and I think it's worthy to have that conversation. And like I said, this is a newness to us, at least recently. I mean, we saw that major transactions in the last administration weren't even voted on, right? They wouldn't have the conversation. A transaction that opened up to more minorities, opened up to more women ownership or women in management. So I think an administration like this that's willing to have the conversation, again, I'm not presupposing where it's going, I'm not prejudging where it's going, but I think the willingness to have the conversation and to take in each side of the issue and talk about it and figure out where to go, I think is worthy.
Thank you, David. And but again, even if you got rid of the scarcity argument, right, you still have the statutory framework of the FCC needs to license in the public interest. So I certainly would agree. Having a discussion what the public interest means in light of the overall media ecosystem is healthy to have. I'm back on my frustration that neither of you defined the news distortion policy.
Well, and therein lies the problem.
Therein lies the problem.
So many of the FCC's rules over the years have been imprecise and not well defined, and it has made it almost impossible to enforce in any rational way. That's what happened with the indecency rules, and that's certainly true of news distortion. And it's one of the reasons why the FCC over the years has tried to be very cautious in what that means in a very limited universe of of what kinds of activities could even qualify for an investigation, and it didn't include these kinds of individualized news judgments. And so to expand on that and to say that it's fine to have what I think is quaint to call a conversation. What we're having here is an inquiry with sort of an open free-for-all, asking for comments to vote on whether or not they like CBS, and more threateningly, whether or not to improve the pending merger between Paramount Global and Skydance Media, and to potentially hold that up. David rightly points out to a number of proceedings in which these kinds of comments by public interest groups and others held up transactions and so on. And I think what you really have to do is limit the government's power in these areas, not to expand on it, because you have to recognize that it will be used politically by one administration versus another. And that's why, not to eliminate every broadcast rule, David, but certainly the ones that allow the government to regulate content and news judgment are the ones that the courts have regulated. The courts have limited ever since the Red Lion decision in 1969. Courts have continually cut back on the FCC's authority to weigh in these areas, and that's really what should happen now.
Well, I'm going to get to one of these questions because it is kind of interesting. And as we see more and more AI generated content out there, on the platforms, probably not yet so much in broadcast news, but what if one of the broadcasters did air as a news program, something that was an AI generated exchange? There were some choice ones floating around there, last week. I won't get into them, but Daniel, would that be news distortion if one of the broadcasters starts doing AI generated news clips?
Yeah, I think so. Kind of given the premise of the question. So in our CBS comment that we filed, we point out news distortion has several components, and one of them is staging the news, right? Bob talked earlier about going to a protest and handing out bricks. And I would think that if you use AI to artificially create content that you report as factual and true, that would seem at first glance like news distortion.
What about you, David?
Well, I think there's a question of whose obligation it is when it comes to AI, and I think that Bob dealt with a little bit of this in his filing regarding AI and requirements of AI. I think if somebody puts on something that is specifically demonstrably false, right? There are opportunities and ways in which either the person that's harmed by it or the public can get it, should be able to have an opportunity to have a discussion about it, right? And what is, as it relates to AI, you don't have to go down the level to AI, right? What about if just somebody gets on, a newscaster gets on and says something straight out that's false, right? I think the problem that we have here is that there is complete uncertainty as to what news distortion means. And that's the conversation that Dan and Bob is having. And I think that's why, like Bob joked, you're not going to get rid of all the broadcasting rules. Do I think that some of these rules are just going to completely go away? I don't think so. But at least for a business, for companies, and it's not just related to broadcast, it relates to every entity that interacts with a government agency. We want to be able to have certainty. We want to be able to rely on precedent. We don't want the rules to change in us after we make investment. The previous FCCs have not shown that. And again, I'm not going to presuppose where this proceeding goes, right? I'm also not going to be insulted by the fact that we're asking comments from the public, given the fact that the FCC asks comments from the public all the time, right? And so that's not going to insult me. But I do think what I hope to come out of this is a path forward in which we can rely on in businesses. We can make this business decisions. We can make journalistic decisions in a way that we can have certainty going forward. Not that we're going to be hauled in front of an FCC based on a rule that may or may not exist, and how it doesn't exist, and get letters from senators saying one way, and 2 minutes later they'll say something else.
I'm almost tempted to end the webinar there because it was very articulate and moving, but we're gonna give our audience a few more minutes of delving into this. So Chairman Carr has said, right, that if broadcasters don't like these obligations, they can hand their spectrum back in, right? Chairman Carr could find other ways to use that spectrum. What's the reaction from Sinclair on that? Even though you're small in that ecosystem, is it an
Right.
exciting ecosystem to be? Is it a deep pleasure to serve localism?
Yes, I mean, we fundamental to our business and our entity has been public, serving the local communities. I think we produce close to 2,500 hours of news a week. All right, that's a lot of news, right? And and the reason that we're still trusted within the local news, and not just us, the other local broadcasters as well. If you go on social, whether it's X, whether it's Facebook, whether it's others, very often the conversation is generated by news reporting done at a local level, right? If you look at the first parties to go down to the border and report on what was happening by the border were the local reporters. The scourge of crime in the communities, that's reported by the local news reporters, right? And it's an investment and it's expensive, but I think it's part of what we look at us as serving the public and serving local communities. That being said, as I said again, I don't think Sinclair or other broadcasters have an issue with certain requirements. It's the constant changing of those requirements. It's the elusiveness of the regulators on the requirements, both in an opportunity to purchase, but also an opportunity to sell, an opportunity to invest, right? If I buy a company and I make it better, and now I want to sell it to somebody, but now I'm told, well, you can't sell it because we decided today that you can't sell it. Or I look at synergies that we can get and we can purchase something else, like every other company, right? Hulu just went and bought their competitor Fubo, right? And they said, we're just, forget the antitrust game. We're gonna, and for a broadcaster to do that, we'd have to jump through the hoops, different hoops. I think what we need is certainty, and we need rules that allow broadcasters and local communities to continue to serve the communities. If you go to other countries, unfortunately, the local news does not exist. Right? I go to Canada often. My wife is from Canada. We go up, sometimes in the summer. You go outside of Toronto, outside of the big city, there is no local news. Right? And you don't have to. I'm not just ripping on Canada. And nobody should. I hope they let me in this summer. But I do think that we have to realize what we do have in this country. The local communities are served very often by, historically, they had newspapers and local broadcasters and radio. Unfortunately, the radio and the newspapers, sometimes often due to decisions by the FCC, right, from not allowing cross ownership between a newspaper, a dying newspaper, and a broadcast, that could have saved many newspapers, right? But ultimately, we are left 4,000 some newspapers have closed down. So the local news is embedded in who we are, how we serve our communities. And I think this FCC is looking for a way to protect that. How they go about it, how they do it is yet to be seen, but I think it's a great conversation and a good future looking forward.
Thank you, David. In our remaining half minute, maybe Daniel, you could elaborate. You touched on some ideas that Carr had in terms of trying to make the editorial decisions, more at the local level for to better serve the local community. Can you elaborate on that, Daniel? And then we're going to wrap up.
Yeah, I obviously appreciate Chairman Carr's leadership on a lot of things, but one thing, even as Commissioner Carr, that I think he constantly reinforced was the point that David made. If you look at Gallup polling of who Americans do trust for news, it's their local stations. And so one of the suggestions we've made, for instance, in the Paramount proceeding, is use more content from local stations on national broadcasts. Have more journalists in local communities, in local bureaus, rather than concentrating them in monolithic, ideological, single-think cities like New York and Hollywood. I think those are practical steps that national broadcast networks could take to really show that commitment to both localism and ideological diversity.
Thank you. Well, I really enjoyed this conversation. Hopefully our audience did. Thank you, panelists. I'm going to turn it back over to Caroline to close us out.
Great. Thank you so much, Tricia. Well, on behalf of the Federalist Society, I want to thank our speakers for the benefit of their time and expertise today. Thank you also to the audience members who joined us. We greatly appreciate your participation. Check out our website, fedsoc.org, or follow us on all major social media platforms at FedSoc to stay up to date with announcements and upcoming webinars. Thank you once more for tuning in, and with that, we are adjourned.